make sure folks understood is that this is an example of the mapping system that the City of Houston is using to implement the regulations for both floodplain and floodway building regulations. This mapping system is based on the FEMA insurance rates maps. Okay, so FEMA wanted to know which property owners needed to have flood insurance, whether or not they needed the increased cost of compliance, extra costs that would be added to their insurance, and so they required cities to designate floodways, and that's not necessarily connected to building codes. It's a separate sort of requirement. The City of Houston, however, chose this mapping system. Harris County is using a mapping system that reflects actual data, it reflects actual topography and actual flood risk, so that you could look at this map and know whether or not a property actually is going to flood. The dark blue that you see closest to, I guess that's White Oak Bayou, is the designated floodway. There's no necessary correlation between being in that dark blue and flooding. I live along White Oak Bayou, and we all know that White Oak suffered quite a bit of flooding. Probably less than a quarter of a mile from me, most of the properties in a neighborhood near me flooded with anywhere from 3 to 7 feet of water in their homes. I never flooded. My home is an older home in an older neighborhood. It's regentrified. I bought the house from a neighbor, and the neighbor had lived in the house some 70 years, had owned the home about that long, and he said it had never flooded. So being in a floodway doesn't really have anything to do with flooding. So I think you need to sort of separate that out. It was, as I said, FEMA this is just a rough estimate on who should have flood insurance, okay? And the city chose this over the maps that indicate true risks, which I think is a significant piece of information. What Chapter 1943 does is it prohibits any and all new construction on vacant land in the floodway. Now this ordinance was passed, the revisions to this ordinance was passed in October of '06. It's not under consideration, it's actually already happened. I bought my home 22 years ago. It was not in any flood hazard zone. I'm inside the loop, I'm in the Heights area. I have a lot that's about 17,000 square feet. My cottage is on one lot. I have an adjacent vacant lot. That was going to be a nice little nest egg for my retirement. However, I couldn't sell it at this moment for someone to build on it if I tried. So the ordinance actually affects me personally in 2 ways, because the ordinance itself prohibits me from doing any substantial improvement. Substantial is any substantial improvement and or repairs. Substantial is defined as 50% of the structure's value, not the land value, but simply the structure's value. So for many homeowners, or particularly some of the older homes, or for any home really, that value can be as low as $50,000, $40,000. So you take 50% of that amount, and as accumulated over 10 years, that is all that you can spend. As the ordinance is currently written, as it has been passed back in '06, you cannot do anything past that 50% accumulated amount. Why does the city want to do this? What was their logic and what was their justification that they have given us all? They stated that because there has been little or no regulation in the city of Houston, that now the city is being swamped. And so now we're going to have to implement these onerous regulations to save the city from flooding. Chapter 1943 was regulated for that. Yeah, okay, sorry. So could live in my house. And that would be only up until I needed more than substantial amounts to improve or repair my home. So I felt like maybe I wouldn't be living there past 10 years should there be something happen to me. So anyway, one of the things that we have heard incessantly, sort of the chatter underground, the chatter in between the lines, is a sweeping vision of green belts. And in these green belts would be detention and parks. And Public Works was happy to tell me that. They spoke about it in public meetings, and it really is a lovely thought to think that up and down all of Houston's bayous and streams, and there's 22 watersheds and 2,200 miles of bayous and streams in the city. And certainly that would be a lovely thought to have green spaces and parks all up and down each and every one of those streams and bayous. It is a lovely thought, but you know, I'm living there. So, no building equals no more worries about sloppy enforcement. And that was one of the other things that came up repetitively, is that they just simply couldn't keep up with all the engineering analysis that was necessary when folks were building in these areas. So it really was something for administrative convenience. And frankly, if they take my land and they take the Floodway property owner's land, it really is a very, very cheap way to manage the drainage and detention and the stormwater management system. You know, stealing stuff is a whole lot cheaper than having to pay full market value. Ask any drug dealer. So, having said that, it's a good opportunity for profiteering after property values have plummeted. We have checked with appraisers, professional appraisers, people who do this for a living, people who have worked for years and years, have massive amounts of experience, and the floodway properties, whether it's in Houston or in a county or in a state or in another state, typically will devalue 90 to 95%. So my property that was valued at about $400,000 is now down to about 40. So one of our concerns is that detention basins that are clearly planned for floodway properties is that we will be given a check for 10%